Please be seated. Thank you. Now, good morning, Ms. Ward. Good morning, Ms. Thornton.
I cannot hear.
Thank you. Commissioner, I hear from Ms. Ward.
Thank you. And we'll, do you wish to take an oath or affirm, Ms. Ward?
I'll take an oath, Commissioner.
Do you have a Bible handy?
I do.
Thanks. Then if you just repeat after me, I, Anne Ward,
I, Anne Ward,
swear by Almighty God
swear by Almighty God
that the evidence I shall give to this commission
that the evidence I shall give to this commission
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, and nothing but the truth.
Thank you, Ms. Ward. Ms. Thornton.
Thank you, Commissioner. Ms. Ward, you prepared a witness statement dated the 20th of October 2021 in response to the summons you received from the Commission dated 8th October 2021. Is that correct?
That's correct.
And do you have a copy of that statement with you?
I do.
And is that a document bearing document ID number CRW 998-002-0927?
Yes, it is.
And is that your signature on page 16 of the document?
Yes, it is.
And are the contents of your statement true and correct?
Yes, they are.
Commissioners, I tender that statement with its annexure.
Thank you. The witness statement of Anne Ward, dated the 20th of October 2021, and bearing the identifier number CRW.998.002.0927 with its annexure, will be admitted into evidence as an exhibit. Thank you.
Thank you, Commissioner. Now, Ms Ward, in the past 4 weeks since your appointment was announced and while you were awaiting regulatory approval, have you had an opportunity to consider in any detail the Crown remediation plan document?
Yes, I have. As of today, it is exactly 4 weeks since my appointment to the Crown Resorts Board was announced. I am not yet a director. I will become a director of Crown Resorts once the necessary regulatory approvals have been received. And in the interim, I have been attending Crown Resorts Board and committee meetings as an observer. I think I've attended some 9 of those in that capacity, as well as the annual general meeting of shareholders and a number of formal induction sessions for new directors. In considering whether I might accept an invitation to join the Crown Board, I set out to satisfy myself that the directors and senior executives of Crown not only acknowledged the need for a significant remediation and transformation program, but that they had the commitment to see that program through and had the capability, in my view, to do it. And I did satisfy myself as to those matters, including, as I mentioned in my witness statement, by meeting with the directors, with the CEO, Steve McCann, and with most of his executive leadership team.
And over those 4 weeks, have you had an opportunity to consider at a very high level the remediation plan itself?
Yes, I have. I've read the remediation plan and I've received reports as to progress against the plan. I think it's a little too early in my time at Crown to say with confidence that I'm across all of the elements of the plan, but I can say, in my view, it is very extensive and it goes to the very core of Crown's governance, of its organisation structure, its risk management frameworks, financial crime, audit and assurance, culture, and gaming operations.
You've had
I was going to say I have also formed the view that significant progress has been made against the plan so far, most notably by the almost complete refresh of the board and the senior executive. And I would expect that the plan or the program of work would be ongoing for some time and would evolve as the program progresses.
Thank you, Ms Ward. You've had substantial experience as a board director. Have you had experience in implementing a remediation program before?
Yes, I have some experience overseeing remediation programs in my roles at Colonial First State Investments and National Australia Bank, as referred to in my witness statement.
And what do you see as the board's role in implementing the Crown remediation program?
I believe the board should take an active role in remediation, particularly in setting and monitoring the cultural transformation underway. I think boards need to set the tone from the top. The Crown Board should demonstrate the values and behaviours to which Crown aspires, and it should assist in building a culture which is ethical, compliant, risk-aware, open, transparent, and should try to create an environment where Crown's people can make good decisions and do the right thing.
Thank you, Ms Ward. Commissioners, that's the evidence of Ms Ward in chief.
Thank you very much, Ms Thornton. Mr Futrell.
May it please the Commission. Ms Ward, my name's Michael Futrell. I'm one of the counsel assisting. Can you hear me clearly?
Yes, I can, Mr Futrell.
You have a copy, I believe, of your a written copy of your statement in front of you, do you?
Yes, I do.
That should make things a little easier for us. Can I start with your curriculum vitae, which is attached to your statement? You've indicated that you've served as a non-executive director on 20 or so boards.
Yes.
And I presume that makes Crown Resorts, when you eventually get there, number 21, does it?
Yes, it does.
Right. And you're currently chair of the board of directors of MFN Group, is that correct?
MNF Group?
Sorry, MNF, yes.
Yes, I am.
And that's an ASX listed company?
Yes, it is.
And you're chair of the directors of Redouble Limited?
Yes, I am.
Again, that's an ASX listed company, isn't it?
Yes, it is.
And do I understand you're also a member of the governing body of RMIT University in Victoria?
Yes, I am.
And a director of Foundation for Imaging Research?
Yes.
And that's a non-for-profit organisation of some kind, is it?
Yes, it is.
Do you have any other roles or employment as matters stand?
No.
Having regard to those existing commitments, approximately how much of your regular week is left available for Crown Resorts Limited work?
Well, over the past 4 weeks, as I said earlier, I have already attended 9 or more Crown Board and Committee meetings, as well as multiple briefing sessions. That is at a time when I'm fulfilling my commitments, the time commitments required of me to my other roles. I would expect over time that the time commitment to Crown reduces somewhat from present, because I am still in induction and learning mode. And so before accepting the invitation to join the board of Crown, I carefully considered my workload, and I feel that it is manageable and I have sufficient time to devote to each of those responsibilities and commitments.
Okay, I was just trying to get a sense of how you're going to fit it all in, because it's obviously quite a heavy workload, particularly now. Yes, it is, but I've had heavier workloads in the past. All right. Now, I think you, in your evidence in chief and in your statement itself, you've mentioned that you had a number of meetings before you agreed to accept your appointment as a non-executive director of Crown Resorts.
That's right.
And I think you've mentioned you met with Mr. McCann and other senior executives.
Yes, that's right.
Who were the other senior executives with whom you met?
So I met with Steve Blackburn, with Tony Weston, with Betty Ivanov, with Nick Weeks, with Alan McGregor.
And
May have missed.
Sorry, I've cut you off. Keep going.
I was just saying I may have missed one or two, but my recollection certainly those.
All right. And were those in group sessions, or were they one-on-one with each of the respective?
No, they were one-on-one.
And I think you mentioned in your statement that were those all meetings that took place before you accepted the appointment, or have they taken place since?
No, they took place before I accepted the appointment. As I said earlier, I wanted to satisfy myself as to the capability and the character of the senior executive team as well as the board.
Yes, I think you said in your statement it was part of your own due diligence in terms of...
That's right.
And did you get an appreciation of or reach an understanding of what you considered to be the necessary turnaround in culture that during the course of those discussions?
Yeah, I did. I certainly asked each of them. Most of them had recently, or within the last 12 months, joined Crown, and I asked them, their perceptions of the culture both before and after they joined.
And so what? And sorry, go on. I'll cut you off again. This is a problem with video.
I think there's a slight delay, but I'll pause before answering, Mr. Futrell. During those meetings, I built up a picture, a composite picture, through their, my discussions with them, and of course, since agreeing to join the board, I have supplemented that view and will continue to do so for some time, I imagine.
All right. And what was your key takeaway from those meetings about what is required for a turnaround?
I guess my key takeaway was that there was quite a lot of work to do in ensuring that the Crown Group had consistent and mature processes and systems so that it could properly manage the risks of the business of Crown.
And what was it about the discussions you had that I think you said in your statement satisfied you that you had confidence in that executive team to lead the organisation to a meaningful turnaround?
It's a difficult question to answer because it's my subjective opinion, having spoken to them, quizzed them on why they joined Crown and what they saw as the challenges for Crown. I think I asked all of them what surprised them since they joined, before they joined to when they got here, and I formed a view, having asked them a number of questions, that they had the capability and depth of understanding and experience to lead the change that's required.
I think of all the people you mentioned, Mr. McGregor perhaps is the only one who is a person who's straddled both periods. Is that right?
I don't know what you mean by both periods.
As in, we'll call it the pre-Bergen era and the post-Bergen era.
Yes, I think so, yes.
And did you form a view about the capability of Mr. McGregor to carry the financial side of the business through into the future?
I did.
And you share the confidence?
I feel Mr. McGregor is a very impressive executive. He's across the detail of the financial arrangements of Crown and has a lot of knowledge of the past, as well as an understanding and appreciation of the change that we've been discussing that's required to remediate Crown and take it forward.
All right. You have mentioned also in your statement that as part of the induction you've been undertaking, you've been involved in some online modules or training. I'm interested really in only two of those for the purposes of today. One is the AML CTF risk awareness training on your online module.
Yes.
What was the nature of that online training? Was it the same that all staff of Crown undertake, or was it catered specifically to you as a director?
No, all of those modules are modules that are mandatory, as I understand it, a mandatory training for all commencing employees, and I think most of them there are a refresher annually or biannually, so they repeat those. So no, they are for all Crown employees. They're not specifically focused on directors.
I see. And in terms of the AML CTF online module, was that something you found useful to gain appreciation of the risks of a casino in that area?
Yes, I did, although I completed that training module only within the last week, I would say, and prior to completing that module, I had already had a one-on-one session with Mr. Blackburn, which is part of the formal induction program for new directors, and I had other briefing sessions on the AML program, etc. So I probably didn't learn myself a lot that was new in completing the online module, but it gave me an appreciation for the training that was being provided to employees.
I see. And in terms of the, I think you mentioned one-on-one. So you had a more in-depth one-on-one session with Mr. Blackburn, did you, about the financial crime program?
Yes. Well, about AML and CTF programs. Yes.
All right. Now you've also mentioned there RSG, Responsible Services Gaming, which I'll refer to RSG for short.
Yes.
What was the nature of that online training?
So that online training, like the other modules, was designed for commencing employees, so Crown staff, and I actually found that very instructive because it included real-life scenarios and decisions that would need to be made by staff on a regular basis around observing signs or behaviours of patrons that might indicate they are at risk of gaming harm. So having not worked in a casino myself, I found it helpful.
And as with AML and CTF, did you have any one-on-one sessions with any executives from Crown Resorts on the RSG component?
I have attended a briefing session on RSG, which was conducted by lawyers for Crown, taking me through the framework and obligations.
I see.
Yeah.
That was not undertaken by Mr. Blackburn then, is it?
No, that was undertaken by others.
Okay. Now, turning to matters more local for us over here, that is, in Perth. Have you had any briefing sessions relating specifically to the Crown Perth Casino?
Yes, I have had a training session specifically focused on the corporate structure and governance arrangements in Perth, which yes, a specific session on those. And I have had a meeting with the CEO of Perth, Lonnie Bossy.
All right. And the briefing session on the structure, no doubt, was that a legal briefing, presumably, given the complexity of it?
Yes, it was delivered by external lawyers for Crown.
All right. Were there any briefing sessions, and I'm now talking specifically about Crown Perth here, that related to AML CTF risks of the Perth casino environment?
Not specifically. I certainly, in my meeting with Mr. Bossy, we talked about some of those issues as they related to Perth, but I don't recall a specific session on AML, CTF, or RSG for Perth alone.
All right, and what about sorry, you've preempted my question. I was going to ask you about RSG, but you're saying you had a general session. It came up, but not specifically to do with
a general session with some elements referring to Perth, as some elements referring to other locations.
All right. Now, I know you haven't been there particularly long, Ms. Ward, but you mentioned in your statement that you are committed to completing the required organisational and industry-specific training.
Yeah.
I just have a question for you. This is in paragraph 28 of your statement. If you could just perhaps explain a little more fulsomely what you mean by organisational training.
Well, learning as much as I can about the Crown Group, the organisation, the different operations, and overlaying on that, I guess, the remediation and change program that's underway.
Okay, and likewise, can you just sort of expand on what you mean by specific required training?
Whatever specific training is required of me, either by Crown or by any of the regulators in the places Crown operates, I'm committed to doing what's necessary to be up to date.
I see. I'm just trying to get a sense, Ms. Ward, whether you have in view specific training that, if you like, is on the program to undertake, or you're just simply expressing a willingness to undertake whatever training is necessary.
I'm expressing a willingness, knowing that there is some mandated training, such as the online modules, the compliance training that is mandated for all Crown staff. So I'm not aware of any other specific industry required training, but if there is, I will do it.
All right. I want to ask you some general questions around the topic of governance, if I may. And you have dealt with this to some extent, or to some degree, in your statement. One of the things you've said is that you have a strong conviction that the tone and culture of any organisation should be set from the top. And I think you may have repeated that in your evidence in chief this morning.
Yeah.
How, in your view, do you demonstrate as a director to the wider organisation that leadership in integrity and ethical decision making you've referred to in paragraph 30 of your statement? How do you see that taking place?
In a range of ways. I think, firstly, that directors need to be visible within the organisations. And so that means being visible physically at the premises. It means being available appropriately to attend events, meetings. I referred there in that paragraph to town halls, which may be curious for those not familiar with the term, but it means where there may be, for instance, an all-staff meeting with a panel of directors on a stage answering questions, taking questions from the floor. I've done that in a number of companies, where particularly companies that are undergoing transformation and cultural change. And I think that's quite helpful to humanise the board, and for the board, the directors, to be able to demonstrate an engagement and understanding of the issues facing people in the organisation, and give an insight into how directors think about ethical decision making around specific real life questions that are asked. So there's a range of things: formal and informal meetings with staff, and visibility within the organisation.
And do you envisage those kinds of activities taking place in Crown Perth environment?
Absolutely.
Obviously, things are a little difficult in the present state of affairs, but in the future.
Yes, absolutely.
Yeah, I think you mentioned earlier you've read the remediation plan. I'm not going to test you on it, Ms. Ward. You'll be happy to know, but
Thank you.
There are some aspects of it that are of particular interest to this commission. One of which is you may have picked up from it as a reference to an implementation of a centralised governance structure. And
yes.
In the most recent version of the plan, there's a reference to being under reassessment, that particular project being under reassessment. Do you have an appreciation or an understanding of what the centralisation process involves as matters stand?
No, I am not familiar with what is happening at Crown, what is being centralised or not centralised, or what is being reassessed. I'm not aware. I have a general appreciation or an understanding of what the term centralised governance might mean, but I'm not across the detail.
Okay, so in terms of the meetings that you have attended thus far as an observer, has there been any consideration given to whether a centralised governance structure is consistent with the obligations of Burswood nominees, which is the licensee in Western Australia, under the regulatory framework here?
Yes, there has been consideration of what I would say the responsibilities of Burswood Limited and the relationship between Burswood Limited and its ultimate parent, Crown Resorts Limited, including discussion around a draft charter for Burswood Limited.
All right, I want to come to that. I take it you've seen a draft charter, have you, for Burswood Limited?
Yes, I have.
Okay, and have you also seen in that context a draft amended constitution for Burswood Limited as well?
Yes.
All right, I want to come back to those because that may. Is that in answer in part to the question I asked about whether the centralised governance structure is under reassessment? Is this part of a reassessment of that, or is it simply giving effect to the centralised model?
Well, as I understand it, those changes to documents were more to be more explicit about the governance structure, if I can put it that way.
Okay.
And to correct in the example of the Constitution, to correct what really is a document that's not fit for purpose for the reality today.
All right. Can I take you to your statement? And this is on pinpoint 0935. It sets out the somewhat complicated structure in Western Australia for the Burswood casino.
Yes.
Now, I take it that you're aware that the actual licensee, the holder of the licence in Western Australia is a company called Burswood Nominees.
Yes.
And it holds that licence and other assets as trustee of a property trust.
Yes.
The role of Burswood Limited is it's the sole shareholder of Burswood Nominees and the only holder of any units in that unit trust.
Yes.
It holds the economic interest, if you like.
The beneficial interest.
Yes. Do you understand also that Burswood Nominees does not have any employees of its own?
Yes, I think the employees are in the other company, management.
That's right. And do you also understand that Burswood Nominees, the directors of Burswood Nominees are in fact employees of the Crown Group?
I'm not 100% sure on the directorships.
Okay. Do you understand, again, I'm not trying to test you on your knowledge of Burswood structure in this board, but do you understand that if the licensee, Burswood Nominees, has any independent directors on its board?
I don't think it does. No, I don't think it does.
All right. Now, do you have an appreciation or an understanding that Burswood Nominees is in fact the company that owes the obligations under the regulatory structure in Western Australia?
Yes, it holds the casino licence, and I think it is the party to the state agreement.
Yes, it is a party, and as is Burswood Limited.
Burswood Limited, thank you.
All right. Now, I think you mentioned a little earlier.
The state agreement, it's an approved company.
I'll stand corrected.
I've been picked up on that
right.
in this room.
I may have misled you, Ms. Ward. Apparently, Burswood Limited is not a party to the state agreement. I wanted to, having given you an overview of the entanglement, I wanted to take you back to a comment you made earlier, which was about, you said something about whether there'd been reconsideration of Burswood Limited in the context of whether there was, I think the words you used was something about fit for purpose, whether the existing...
The Constitution.
Yes, correct. Now,
yeah.
Has in that framework, has any consideration, to your knowledge, been given to the question of whether the existing or any proposed structure for Western Australia is appropriate or fit for purpose, having regard to the fact that Burswood Nominees is the licensee, that is to say, the company with the obligations to the state?
Mm. Mm. So, as I understand it, the structure dates back decades to, firstly, a time when the trust was a public trust, so the unit holders of the trust were the public, and that was a fairly common, I think, 1980s, 90s kind of structure. That then morphed into a corporatised structure where Burswood Limited came in, and it was a public company and its shareholders were the public, but it became the 100% owner of the units in the trust. And later, Burswood Limited was taken over, so it became a wholly owned subsidiary eventually of Crown. So I see the arrangements, the constitution of Burswood Limited, when I looked at that, was what I would call a typical listed company constitution, which refers to CHESS and ASX listing rules, etc., which clearly no longer apply for Burswood Limited, as it is not a listed company. When I look at the trust and nominees structure, that dates back to a time when the public ownership was at the trust level. So I see that structure as somewhat historic. It could have been rationalised at the time when those changes made. I don't know why it wasn't, but I don't know. I'm not sure that trust structure is appropriate. I know that any changes to that structure would require would require consultation and agreement with the West Australian government. But I think that I view the structure as historic.
I understand. I'm really focusing not so much on the legacy structure, but the response. Who within that structure has the responsibility as licensee under the West Australian regulatory framework?
Well, would be nominees as right. The licence holder, but nominees would have fiduciary obligations as trustee for the trust to Burswood Limited.
Yes, I'm focusing here on the responsibility and obligations owed to the West
to the government.
The government. So the point of my question is really whether any consideration has been given to the adequacy or fitness for purpose of the current governance structure, having regard to that observation that Burswood nominees is in fact the company within that structure with the responsibility to the government of Western Australia.
Sorry, I'm not sure I'm following your question. Could you repeat?
The question is whether there's been any consideration given to the appropriateness of the current structure, the way Crown Resorts has organised itself in terms of the composition of boards, charters and so forth, having regard to the fact that Burswood Nominees is the party that owes the duties to Western Australian government.
I don't know.
Can I ask you, I know you mentioned this earlier and I think you may have mentioned this again, which is the proposal to introduce a charter for Burswood Limited. This is, you may not have it in front of you, it's CRW.701.009.5375. I don't know if you've seen, you may not recognise it now, it's got so much black on it, Ms Ward, but you may have seen this document in one of the meetings you've attended.
I may have, yes.
All right. Perhaps if we scroll through the redactions to there's a document entitled Burswood Limited Charter, Attachment 1.
Yes, I see that.
I think you may have seen this one before.
Yes, I'm not sure of the version, but I have seen recently a draft of the Burswood Limited Board Charter, and that looks like it.
Okay, I just want to draw your attention to clause 4.1, which is on pinpoint 5381. And if the proposal has changed at any point, please let me know. If I could just draw your attention to clause point 1, as I read it and understand it, the proposal for the charter is that there must be at least one independent director, a non-executive director of Crown.
That's the wrong clause blown up there, I think. Sorry, I think E says at least one of the directors must be an independent non-executive director. Yes.
There must be at least 3.
Yes.
One must be from, I think, the Crown Resorts Limited Board, non-executive director.
Yes.
Saying. And F indicates that one director, so it's on the following page, must be the CEO or Managing Director of Crown Resorts.
Yes.
There doesn't appear to be any requirement here for there to be any other number of independent directors on the board, Burswood Limited board. Is that your understanding?
That's my understanding.
And could I take you to attachment 2, because you mentioned the constitution, which starts on page 5389, and again, this may not be the current version, but it's a version.
Mm-hmm.
And as you have foreshadowed, most of the red lining in blue is tidying up the constitution to remove the provisions that would be required if Burswood was a listed company. But there is one I want to draw to your attention on, pinpoint 5415, which is the insertion of the clause 15.13. And I think you've said in your statement you've kept your practice in this studio. I'm trying not to ask you a question of legal advice for legal opinion.
So
1513 is a provision that has been inserted or is proposed to be inserted that deals with one of the provisions in the Corporations Act that deals with subsidiary companies. And it will,
yes.
allow the board of Burswood Limited to act in the best interests of Crown Resorts, and that would be considered in the best interests of Burswood Limited itself.
Yes, that's what it says.
Is that? Do you understand it to be a current proposal for the amendment to the Constitution of Burswood Limited? To give
That's what you're showing me.
I understand from showing you. But did you have an appreciation of that as part of your observations in the meetings you've been attending?
That element hasn't been discussed specifically in any of the meetings that I've been in, but that is a fairly standard arrangement under the Corporations Act that a subsidiary company is authorised to act in the best interest of the holding company.
Yes, but
in my understanding.
Yes, but again, just going back to the questions I was asking you earlier about the appropriateness of the structure, given that Burswood Nominees is a licensee of a casino licence in Western Australia, do you have any sense or view about what might be regarded as the best interests of the company as a whole in that context?
Which company as a whole?
Burswood Nominees.
So I don't see any inconsistency in Burswood Limited acting in accordance with the obligations that it has within its operations and acting in the best interests of its holding company. Is that what you're putting to me?
In part, yes. But really the question is whether you see, and let's leave the names of the companies to one side because the structure can get in the way. A corporation that is the holder of a casino licence, do you see the question of what one regards as the interest of the company as a whole, to what would your view be about the scope of that interest?
Well, in this context, I'm sorry, I'll put it in my words. In this context, the obligations of the holder of the casino licence would be to do everything necessary to maintain that licence and comply with the conditions of that licence, and that would be entirely consistent with the interests of the holding company.
Yeah, so perhaps I'll put it into two abstracted terms, Ms. Ward. So typically one would see the interests of the shareholders as part of the interest of the company as a whole, the members,
Yes,
potentially creditors or contingent.
yes, to an extent.
Do you see there to be any aspect of company, the concept of company as a whole, to include what one might call being a good corporate citizen or social responsibilities?
Yes, and that exists irrespective of whether the company is a licence holder.
All right. And do you see there to be any specific aspect of being a casino licence holder that brings that concept into sharper focus?
Yeah, I think that's a good term, sharper focus, because there are community interests in the conduct of casinos that don't exist in relation to the operation of other businesses. So yes, I would agree with you.
All right. So would you accept, though, in terms of the company that holds that responsibility for Western Australia is Burswood Nominees?
Well, Burswood Nominees and yes, I really couldn't comment on the division between Burswood Limited nominees and management.
All right. Perhaps I'll put it to you slightly differently. Do you see there to be any distinction between Crown Resorts obligations broadly to its best interests and those of Burswood Nominees?
Well, Crown Resorts has other operating subsidiaries and other assets that don't impinge on the operations or the responsibilities of Burswood Limited and the Perth Group. So Crown Resorts' responsibilities go broader.
Yes.
But the Perth, what I think of as the Perth Group obligations and responsibilities are a subset of Crown Resorts.
All right. Now, can I just take you back to your statement then? I may need to return to this topic, as abstract as it might be, in a moment. In paragraph 44 of your statement, you have indicated who you understand to be the members of the directors of Burswood Limited.
Well, that is my understanding of the current plan.
The current plan, I see. So I noticed that Mr. Bossy's name is not mentioned there. Is that because Mr. Bossy is not a feature of the current plan?
Yes.
And when your statements, the day the 20th of October, when did you become aware of that component of the current plan?
Well, the current plan, as I've expressed it there in paragraph 44, was discussed at a Crown Resorts board meeting.
And when?
I can't recall the date, but perhaps the 17th of October. It was a Sunday.
Okay. All right. Now, I would like to put some things to you in terms of a particular Western Australian context for the structure, and I just want to see what your views are on the conclusion of this. So I'll just put some things to you first. In the present structure, in effect, Burswood Limited is accountable to Crown Resorts. Would you agree with that proposition?
Yep.
And it doesn't in any sense operate independently of Crown Resorts.
I'm not sure that that's correct.
All right.
I
Well,
don't know what you mean by independently.
Mr. McCann is the CEO of Crown Resorts and he's a director of Burswood Limited.
I think so. I'm not 100% sure who the current directors are. This paragraph's referring to what I understand to be the plan, which I don't think is yet implemented.
All right. Well, let's assume that the plan's implemented. Mr. Carter will be the chair. He's a director of of Crown Resorts.
Crown Resorts, yes.
Mr. McCann's the CEO of Crown Resorts.
Yes.
And Ms. Fuster is an independent Perth-based director.
Yes.
In that context, the lone, if you like, independent Western Australian voice on the board is Ms. Fuster.
Yes.
Now, I've been over this with you a little earlier, but one of the considerations I want to put to you is that Burswood Nominees is the holder of the casino licence. We've been over that ground. It has the statutory obligations of Western Australia. Second, it is the party to the state agreement in Western Australia.
Yes.
Now, Crown Resorts is not a party to that agreement. And the third consideration I want to put to you, which is mentioned and is dealt with in part in your statement, is the requirement in the Constitution of Burswood Limited to have its head office in Western Australia.
Yes.
And you'll recall that that's defined in a way that the head office means the place of business of the company where the central management and control are exercised.
Yes.
Now, just to pause on that part for a moment, there are three elements to that. One is it's central. The second is there's management, and the third is control. Now, having regard to those three considerations, licensee, party to the state agreement, and in the case of the intermediate parent company, Burswood Limited, a requirement that it have its head office in Western Australia. Do you think in that context there's a case for constituting the board of Burswood Limited or Burswood Nominees to comprise of an independent board, a completely independent board from Crown Resorts?
No.
And why do you say that?
I don't understand why it is thought that an independent board is required.
In the context of those three elements that I've taken you to, you consider an independence is not a factor?
Not necessarily.
All right. Now, have you had an opportunity to, I know it's early days, to consider the recommendations that have come out of the Victorian Royal Commission?
Only in a very superficial manner.
Yeah, I don't expect you to have had time to consider them in any great detail. One, as I understand, one of the recommendations that has come out of the Victorian Royal Commission is a recommendation for an independent board for Crown Melbourne.
And when you say independent board, you mean majority directors of that board independent of Crown Resorts?
Yes. Now, do you have any view about whether there are implications arising from recommendations in the Victorian Royal Commission for the appropriate structure in Western Australia? I know it's early. It may...
No, I haven't. I have not turned my mind to that. I'm barely across the recommendations themselves, let alone understanding the implications for Crown Melbourne.
Okay. So can I come back just to the Burswood Limited constitution, if I may, and you have dealt with this in your statement. No, I just realised you have said that you haven't been there long enough to really form a view on the extent to which there's been compliance with that part of the Constitution. So I'll withdraw what I was about to ask you. So just leaving to one side the question of whether there is currently compliance with Article 3.12, do you have a view at all about the extent to which governance and responsibility for governance should be more properly reposed in the licensee, that is to say, in Burswood nominees?
I don't really have a view other than what I said earlier, that I think the legal structure, the separation of nominees and Burswood Limited is an artefact of history. It's a legacy issue. And I kind of think, as I said, about the Crown Perth being the group. So I've not thought deeply about the different obligations between those companies.
All right. Can I ask you now just some questions about the interaction between Crown Melbourne and Crown Perth? You might recall some questions were asked of you relating to some provisions in the management agreement that is the state agreement in Victoria. And I could draw your attention to paragraph 48 of your statement, where you have indicated that you suspect the arrangements were put in place to ensure that Crown Melbourne remained the preeminent gaming facility in Australia. Do you understand that, in effect, the object or purpose of the provisions of the management agreement in Victoria is to essentially entrench that position within the Crown Group?
I think that's the intention of the clause.
And it leaving aside the whether or not it might be a practical possibility, it has the effect of preventing, doesn't it, any other casino facility that Crown may operate from becoming the preeminent gaming facility in Australia.
Well, it wouldn't prevent that, but if that was to occur or to be seen to occur by the Victorian government, I suspect there would be a claim that the clause had been breached.
So really the point is, although there may well be advantages to Crown Perth in the short or medium term, but it really guarantees that Crown Perth could never challenge Crown Melbourne for preeminence, doesn't it?
I think it's unlikely, whilst they were part of the same group and whilst these provisions remained in place.
So other than the sort of flagship element of the provision, there's another aspect to it I want to ask you about, which is it requires in effect, or do you understand to require in effect that the conduct of the Crown Perth business is to be undertaken in a way that promotes tourism, employment and economic development generally in the state of Victoria?
Sorry, could you repeat that?
Do you understand the clause, and I'm referring here to the clause 21.1R, to require that, in effect, Crown Perth's business is conducted in a manner that promotes tourism, employment and economic development generally in the state of Victoria?
No. Crown Perth.
The holding company group, if it pursues anywhere in Australia a business similar to that of the company, will use its best endeavours to ensure that such business is conducted in a manner which is beneficial to that business and which promotes tourism, etc., in Victoria.
Yes, sorry, I see. I was looking at the wrong clause. Yes, I see that.
So this is really what a question of your understanding is. Do you understand from that business cannot be conducted in a manner that promotes tourism, employment and economic development in Western Australia alone?
Well, this clause says which is beneficial both to that business and to the company, which I take to be Crown Melbourne, and which promotes employment, economic development generally in the state of Victoria. So I would take that to be both.
Well, it might be both.
To promote.
It might.
Yeah. Well, it says both.
Now, in paragraph 49, you have indicated that there's a significant benefit to Crown Perth in having a financially strong head company that promotes robust governance and consistent risk management across all venues.
Yes.
That doesn't necessarily require that the head company be located in Melbourne, though, does it?
That the head company, no, it doesn't.
But those benefits can flow wherever the head company is located.
Yes.
So do you consider these provisions to provide, would you consider these provisions to provide any impediment to Crown Perth competing on a level playing field with Crown Melbourne for patronage?
I don't see how they prevent that.
Can I ask you now some questions about if we just turn to the remediation plan itself and some aspects of that. In July, the Council for Crown indicated that in opening into this commission that Crown was responding to what were referred to as deficiencies, and those were matters that were aired in the Bergen inquiry and subsequent other inquiries, and made reference to the remediation plan, to which you've also referred earlier today. Have you a view about what aspects of what might be termed the deficiencies that are addressed in the plan are the most serious or acute?
Well, as I said in my earlier statements, the remediation plan is very extensive and it goes to every level, almost every level of Crown's operations. And so leadership has almost completely changed at board and senior executive level. So I'll leave those elements to one side. I think that there have been clear deficiencies outlined in the financial crime programs, particularly AML and CTF programs. That's urgent to remediate and is well on the way. Well, progress has been made. I think responsible service of gaming was another
item for senior management renewal. Do you understand that process to effectively now be complete, or is there any additional changes in view of which you're aware?
I'm aware that the process of board renewal will continue, and I think Dr. Switkowski has given evidence about the plans there to increase the size of the board of Crown Resorts. I think that in discussions with Mr. McCann, he has some other changes potentially under consideration in the executive team, whether that is the structure or the individuals in roles, I couldn't say, but I think he anticipates that the executive team will be, I think, stabilised or, stabilised within a number of months.
And do you understand whether any of the possible changes to structure or personnel will affect Crown Perth?
I don't know.
All right. Now, in the context of remediation, there's obviously risk management forms a part of that process, and you've indicated yes. you have experience in risk management in your statement. Can I ask you, just having regard to the experience you've had in risk management, whether you have a view about the adequacy or likely effectiveness of the remediation plan in addressing risk management?
I really couldn't say because I've read the plan, but I don't have a full understanding of the current status of the risk management function and the risk management frameworks at Crown. It's too early for me to say.
Have you familiarised yourself with the risk management strategy and framework documents?
I've read it. Read the documents. Yeah, some of them.
Can I, perhaps if I could ask that we call up CRW.512.041.0055. I take it you've seen this document previously?
Yes, I have.
Could we scroll to pinpoint 0067, please? And I just want to draw your attention to the heading risk appetite. Have you considered this risk appetite statement as part of your induction to Crown Resorts? I've
read this document superficially. I couldn't I hope you're not going to test me on its contents.
No.
And I haven't had any. I haven't had any specific induction training on risk appetite.
No, my question really was going to be, having regard to your experience in this area, whether you had a view about the nature of this risk appetite statement and whether it, in your view, captured adequately what you consider the risk appetite for Crown Resorts should be.
No, I haven't considered that.
I think you mentioned, so that the quite obviously money laundering and terrorism financing risk has been an important focus of the Crown Resorts remediation plan.
Yes.
Do you understand that there have been any aspect of that that focuses not so much on the specific risks of money laundering and terrorism financing, but criminal infiltration, the risk of criminal infiltration into casinos more broadly?
Well, I think that is encapsulated there in the bullet point that's being shown now, that Crown does not have appetite to accept material risk related to any association with or influence from criminal elements. I have not been, I can't recall being involved in discussions of that element in the past 4 weeks at any of the meetings I've attended or observed.
Sorry, I'm not actually referring to the documents on the screen. I'm asking you a more general question about your understanding of the remediation plan and whether it, to your knowledge, is directed not only to addressing risks associated with money laundering and terrorism financing, but also risk of criminal infiltration of casinos more broadly.
Well, I know that the remediation plan addresses elements, matters such as no longer dealing with junkets and the like because of the risk of influence or involvement from criminal elements. So there are parts of it that do address that.
Do you understand there to be an enterprise-wide risk assessment being undertaken to deal with money laundering and terrorism financing risks?
Yes, I do.
And do you understand it to be proposed to be completed and provided to the Crown Resorts Board later this year?
That's my understanding.
All right. Do you have a view about the necessity and importance of that project from the perspective of the remediation plan?
I think it's very important to have an enterprise-wide assessment of risk.
Have you had an opportunity to form a view about the likely time frame within which the that risk process will be completed?
Well, my understanding is that the enterprise-wide risk assessment in relation to money laundering and financial crime will be presented to the board in the next month or two. But I haven't seen that, so I don't know what the next steps will be, whether that will be complete, whether it will be ready to be implemented. So I couldn't say.
All right. And do you have, and you may mean you're not able to answer this question either as well, but do you have any sense of the likely time frame during which the controls or means of managing risk are likely to be implemented and fully operational within Crown Resorts?
Well, a number of controls in relation to financial crime, as I understand it, have already been implemented. Some of those controls I understand to be manual and requiring enhancement to become automated. I couldn't give you the detail of what's involved there. So there are some controls in place, and there is a continuous improvement process of enhancing and automating those controls.
Do you have a view at all about the extent to which Mr Blackburn's continued employment and involvement in this process is critical to Crown Resorts delivering the outcomes of that project?
I think from what I've seen, his involvement has been absolutely crucial in the work that's been done to date. Whether his continued employment is essential in implementing the program that's been put in place, I would hope he remains employed.
Well, the point of my question really is whether without him you think it can be done.
I think it can be done without him, but I hope we don't have to do it without him. If he was not there, then we, no doubt, Crown would seek to employ another executive of his capability and experience.
Right, I wonder if that might be a convenient time.
Yes, Ms Ward, we take a break at this time of the morning, so we'll come back at, I think it'll be 2:35 p.m. your time. Yes.
Thank you.
So we'll come back at 11:35. Thank you.
All rise.
Please be seated. Thank you, Ms Ward. Neutral.
Mate, please. Ms Ward, if you've got your statement in front of you, could I ask you to navigate your way to pinpoint 0940? And there's a heading there.
Sorry, which?
It's the top right-hand corner, last four digits, 0940, paragraphs 50 and 51 and question 26.
Yes, I have that.
Just direct your attention to the paragraphs you've given under question 26 and in answer to the question. From the answer, or from the paragraphs 50 and 51, it's evident that you consider that the Crown Group has obligations and duties to minimise gambling-related harm resulting from operations at the Perth Casino, correct?
Yes.
And you're not, at this stage, prepared to express a view on the limits of those obligations and duties because you don't consider you yet have a sufficient knowledge of the issue and the systems and processes that Crown Group has. Is that a fair assessment of what you're saying?
Not only that I'm not prepared to express a view, I don't have a view at this point. I haven't formed my view.
Okay. I assume, however, you must have a view about what you would regard as the minimum obligations and duties to be in that regard.
Not really.
All right. Well,
I know. I guess what is being done at present I would regard as the minimum, as I accept the suggestions that more needs to be done.
okay. So, acceptance of the suggestion that more needs to be done, does that, do you understand that to be an indication that there's an acceptance that whatever is being done is not in some way fully adequate?
Well, I couldn't express a view because I'm not completely across what is currently being done. But I think it is accepted that more needs to be done.
All right. I just want to get a sense of your, if you like, your orientation on this issue, at a general level. So,
Sure.
do you consider, or would you agree that? I'm talking now about Crown Perth specifically because that's the subject matter of this commission. Would you agree that Crown Perth has a responsibility to inform patrons of the risks associated with gambling-related harm?
Yes, I would.
And would you agree that Crown Perth has an obligation or a duty to provide assistance to a patron if the patron requests it in respect of gambling-related harm?
Yes.
Possibly a more difficult question is: Do you consider there is a responsibility of the licensee for controlling patrons' gambling and minimising harm to the patron?
Well, there are a few elements to that question. You said the licensee controlling. I think whatever obligations arise under the licensee would have an obligation to ensure there are systems in place to comply with those obligations, not necessarily that it did it itself. That's the first part of my answer. The second point is you used the word control, and I don't fully understand what you mean by control patrons gambling.
Okay, so what I'm trying to draw is a distinction between, if you like, identification. One is education. I think you've agreed is an obligation to educate. The second
Well,
is
information and education.
yeah.
Then secondly, if you like, when a patron recognises themselves they have a problem, then to provide assistance. So
Yes.
in those two areas. So by the time a patron is at the point of recognising they have a problem, in a sense, it's a little late. So really, I'm focusing on whether you have a view about the responsibility or obligation to implement preventative measures. In other words, to prevent the problem arising in the first place.
So I'm not sure I agree with you, but that by the time a patron recognises they're at risk of harm, it's too late. I don't know enough about the topic to know whether that is correct. And I think that the casino operator has some duty to take steps to recognise indications that recognise behaviours that may indicate a patron is likely to experience harm. But I also understand that some patrons will not exhibit observable signs that they are likely to experience harm. And that's what I was referring to in the paragraph around technology, that there are some systems that a casino operator can use to detect unusual changes in a patron's the type of play or frequency of play, where a patron may not recognise themselves that they are at risk of harm, but the casino operator may be able to identify those potential indicators of harm, and if it did, then probably would have some obligation to intervene with the patron.
Okay.
So I'm sorry, does that answer your question?
It does in part. I think it's, as I understand the answer, it's directing or focusing attention on detection, either at an earlier point in time of a person who may be developing a pattern of behaviour that indicates potential harm. So in terms of if you like, what's within the control of the casino operator, and you mentioned systems, do you consider there to be any aspect of that responsibility to design the games that are offered to patrons in a way that mitigates the risk of harm to patrons?
Well, as I understand it, some of the games that are offered on the electronic gaming machines, for instance, Crown doesn't design. Those EGMs are purchased from other parties. To the extent that Crown is involved in designing games, yes, I think there would be some obligation to take into account elements of whether the design of the games is likely to lead to greater risk of harm.
Okay, and there are other things that are within the control of Crown, are they not? For instance, modifying or restricting how and when it offers the services, the gaming services.
Yes.
So, you've indicated that you are aware of some steps that are being taken by the Crown Group to improve its responsible gaming capabilities. Are you able to expand a bit on what those steps are?
Yeah, well, I'm aware of a number of things, and this is, I'm sure I'm not aware of everything that Crown is doing, but I am aware that there are steps being taken to improve the support and services that are provided at each of Crown's gaming facilities. So in Perth, for instance, I'm aware that the Responsible Gaming Centre is currently under expansion and refurbishment. So the physical centre, I understand it, is going to be about 3 times the size it had previously been, and that the resourcing, the staffing for that centre will be increased. I couldn't tell you by how much. I'm also aware that more broadly, Crown has convened or established an independent advisory panel consisting of experts, academics whose field of research is in this area, to help Crown improve overall its frameworks and tools and support systems for customers. And that's by way of understanding how the cliche global best practice, what is happening, how is thinking evolving in this area around the world, and what can Crown do to improve its responsible service of gaming programs.
In the context of the money laundering, terrorism financing risk, there's an enterprise-wide risk assessment being undertaken. Do you have a view on whether a similar kind of enterprise-wide risk assessment would be desirable in the area of responsible gaming?
I think it would.
And do you have a view on whether that should involve the gathering of an identification of specific risks associated with specific kinds of games?
I imagine it would. Yeah.
All right, and would you agree then that part of such a process would allow the casino operator to identify more clearly what the risk causes are and what controls could be put in place?
Well, I imagine that would be one of the objectives of an enterprise-wide risk assessment.
And to your knowledge, is there such a enterprise-wide risk assessment being undertaken in the responsible gaming area?
I don't know.
I just want to ask a couple more questions on this topic, because Mr. Blackburn has responsibility at the executive level for gambling-related harm minimisation, if I could put it that way.
Yeah.
Clearly, he has a very large degree of expertise in the financial crime area. Do you have a sense of the degree to which he has the same or a similar depth of knowledge in the harm minimisation area?
Well, I don't think he, as I understand it, his previous roles were focused on financial crime and AML, CTF risk specifically, rather than responsible service of gaming. So I don't think he has the same depth of experience in this area as in the financial crime elements.
Do you have a view about whether it's appropriate for someone to divide their time between both financial crime, given the amount of change that's taking place in that area, and responsible gaming simultaneously?
Well, he's not doing it all by himself. He has teams of people in both areas that are supporting him, and he has, I understand it, recruited a number of experienced people in both parts of that portfolio. So with appropriate resources, I see no difficulty in one executive being accountable for both those areas.
Okay, and do you have a sense or are you able to give us an understanding of the extent to which you consider that an appropriate level of attention is being given at the senior management level to the responsible service of gaming area?
I think there is a great deal of attention being given. I would say it's a different type of attention, because the AML financial crimes obligations are very expressly set out in the law and regulations, and so there are a lot of well-trodden paths of programs and processes and systems and controls that need to be put into place. I don't think there is the same level of specificity in the law and regulation around responsible service of gaming. So it's a less technical area, if I can put it that way.
All right. Thank you. You've answered my question. Can I ask you some questions now about somewhere we started a little earlier in the day on culture, and you have indicated that there are, given that you haven't been there that long, there's aspects that you can't express views on in any detail. But are you able to provide an insight into what your understanding is, leaving aside, you've already mentioned changing of the directors and senior managers, what do you understand the organisation and reform that is necessary within the Crown Group?
Well, I think there are a lot of things required. Culture is a very, in one sense, it's a very amorphous topic. In another sense, it's the practical day-to-day of how people behave and how we do things around here. So everything that you do in how an organisation sets up its people function, from attracting and hiring people, the remuneration structure and philosophy, the setting and articulation of values and desired behaviours, the communication of those values, the setting of KPIs or KRAs for individuals, what they're going to be measured on, the performance management structure, where people, their performance is evaluated, the reward and recognition program, what gets celebrated, where there is bad behaviour or poor culture displayed, what are the consequences for that? All of those things go to establish the culture. And so that's a long way of saying it touches very many things that an organisation does.
Do I understand, because the question was really directed to whether you had an understanding of what reform was necessary, and you've mentioned a long list of aspects of culture. Are you suggesting you've formed a view that every aspect of what you've described as culture is in need of reform?
No, I'm not describing those as aspects of culture. I'm describing those as the artefacts within the organisation that help to drive culture. And as I understand it, pretty much all of those are under review under the leadership of Tony Weston. And I simply don't know the degree to which reform is required in any one of those elements. So I was answering more generically than specifically to Crown circumstances.
All right, but I'm just trying to get a sense of what's underway. So what is, if I understand what you said correctly, is essentially a wholesale reconsideration of the Crown culture.
Sorry, of what? You
The
just
Crown.
cut out there.
A wholesale reconsideration and review of the Crown culture and all of the aspects of it you've described.
Yes, yes.
And you have indicated that you have a view that you will be able to assist in the implementation of organisational reform. How do you see you participating in that implementation role?
Well, I will at some point become a director of Crown Resorts, and what I do will be in that capacity. I will not be an executive. I will not be a full-time member. So whatever I do will be as part of the Crown Board. And going back to the questions you were asking me earlier, what should be the role of directors in helping to build and drive a constructive culture? It goes to all of those things: being visible, demonstrating the behaviours and values that we want to see throughout the Crown, being a role model for ethical decision making. Pretty much everything that you do as a director can contribute to how you inform the culture, set the tone from the top.
Okay, now you've indicated you've read the Deloitte culture report, which
Yes.
referred to in your statement. In other organisations you've been involved in, have you had the occasion to see a similar kind of review?
Yes, I have.
And in other organisations, have the results been of a similar character or different?
You'd have to be more specific.
Well, there are. You've indicated there might be a number of factors that have contributed to some of the results that Deloitte have recorded in the report. Other influencing factors, but leaving to one side the extent to which there may have been influencing factors, the report does contain some quite alarming conclusions about Crown Resorts culture, does it not?
It does.
And so really the question is, in other organisations, I'm trying to get a perspective on whether we can cut the influencing factor noise out and inform a view about the state of culture compared to other organisations you've been involved in.
So the methodology that Deloitte adopted is a very familiar and common methodology that organisations adopt either through an external consultant like Deloitte or themselves. So typically these kind of reviews, in my experience, are built upon asking staff to complete some form of questionnaire or survey, and then taking the result and provide comments, and then taking the results of those and aggregating across properties or across types of employees and coming up with conclusions. Inevitably, the result of the review is based upon an assessment at a point in time. And so whenever a board that I'm a part of has looked at the results of an engagement survey or a culture review of this nature, you would have cognizance of the external factors or what was happening in the company or in the industry or in the world at large at the time when the survey was answered. In the case of the Deloitte review, there were some fairly profound issues occurring at that time, as has been stated in the survey itself. Not just the regulatory inquiries and the media scrutiny, but the response to the pandemic in the various places where Crown staff are employed, plus very significant changes in leadership of the organisation. So I would expect most employees who answered the survey or participated in the focus groups were feeling uncertain, and were feeling concerned, and were feeling perhaps demoralised. So that is a relevant factor to take into account in how you interpret the results.
That may be so, but in any case, it has a value, does it not, as a tool for identifying a culture at a point in time?
Absolutely, yes. It has a great deal of value, and having a review of this nature gives a very good baseline, I guess, from which to work, and it should give managers in the organisation important data to assist in implementing the cultural change that's required.
Do you have any sense of the depth of change that is necessary or will be required?
When you say the depth of change,
well, you've said,
what do you mean?
You've said that I think change starts at the top, but would you agree that it need not only start at the top, but it needs to filter right the way down to the people who are having the day-to-day interactions?
Yeah, it's top down and bottom up and everything in between.
So what appears to be reflected in this report, you've obviously read it, is there's a level of management beneath the senior management that are mirroring, if you like, some of the cultural issues that we've seen reflected in the Bergen report, for example. So there's findings of a majority of staff believe it's necessary to bend the rules and work around policies and procedures to get the job done, for example, that conclusion. Would you agree with the proposition that if you're going to change a culture, you need to change it right the way through the organisation?
Yeah. Although to that point, I would make the observation that I think it would be wrong to assume there is one culture throughout the organisation. The culture is, by definition, made up of a number of subcultures or microcultures, and I imagine there are different aspects or different observable features of culture as between Melbourne and Perth, for instance, depending on which business unit you're looking at or which function you're looking at. So culture is a multifaceted thing.
Yes, I'm sorry, Ms. Ward. I'm not trying to suggest to you that this is all, every aspect of Crown Resorts is bad or anything like that. I'm just suggesting that if one is going to give effect to change, you have to give effect to change throughout the organisation. Would you agree with that proposition?
Yes, I would.
And one of the conclusions that is identified in this report is that there are examples of poor behaviour from executives and general managers, including things such as bullying and favouritism and things of that nature at a lower level of management than the senior management. The question for you is really whether there is, to your knowledge, any aspect of the remediation plan and cultural reform that will seek to address those kinds of cultural issues at a lower level of management.
Yes, I understand there is.
And what's your understanding of how that will be dealt with at a more granular level?
I couldn't give you the detail of that. I would be speculating.
All right. But do you understand there to be a recognition that all levels of management need to be considered as part of the cultural review?
Yeah.
All right. I really have just one last sort of a bigger picture question for you, Ms. Ward. Given the road that appears to be in front of you when you eventually get your approval to become a director, can I ask you why you've accepted the position as a director of Crown Resorts?
Yes, thank you for that question. I view Crown as an iconic Australian company that has contributed significantly to the different places of the economies of Victoria and Western Australia. But it's a company, I think, that has lost its way and needed and needs an ongoing, very significant transformation program. And as I said at the beginning, I would not have accepted the invitation to join the Crown Resorts Board if I didn't have confidence that the leadership that's been put in place was capable of effecting that change and that Crown was capable of remediation. And so I'm attracted to the challenge of assisting that remediation and restoring Crown to the position that it should be in, restoring the trust and confidence of its regulators and the communities in which it operates, and restoring the pride of people who work for Crown to be part of Crown.
Thank you, Ms. Ward. I've no further questions.
Thank you, Mr. Futrell. Do we have any council that are not in the room? Are there any applications to ask questions, Ms. Ward?
I just have a couple of questions.
Yes, Mr. Garris.
Ms. Ward, my surname is Garris. As you know, I act for the Crown Companies. I just have a couple of questions for you.
Yes, Mr. Garris.
Thank you. Mr. Futrell asked you some questions about the Burswood Limited Constitution, and in particular, he took you to clause 15.13. I'll just remind you that that's the proposed amendment which provides that each director is authorised to act in the best interests of Crown Resorts Limited, and in doing so will be taken to be acting in good faith in the best interests of Burswood Limited. Now, as I understood the question that was put to you, suggested that there may be a conflict between acting in the interests of Crown Resorts Limited and Burswood Nominees Limited, the subsidiary of Burswood Limited. Would you agree with me that the casino licence held by Burswood Nominees Limited is its most valuable asset?
Well, there is the licence to operate the casino, and then there is the physical property.
Okay,
So are you distinguishing? Sorry?
Let me rephrase. Would you agree that the licence is one of its most valuable assets?
Yes, I would.
Thank you. And would you agree with me that it would not be in the interests of either Burswood Limited or Crown Resorts Limited to do anything that might jeopardise Burswood Nominees' licence?
Yes, I would agree.
Thank you, Ms. Ward. I have no further questions.
Thank you, Mr. Garris. Any other applications?
Thank you. Ms. Ward, can I ask you about the board of Burswood Limited? Do you think that a majority of the board of Burswood Limited should be independent of shareholders and of CRL?
No, I don't think that's necessary.
And why is that?
Well, I don't understand why it is thought to be necessary.
You don't think that it's necessary for them to be free to exercise their judgment of what's in the best interests of Burswood Limited, unconstrained by loyalties to other entities?
I'm not sure why that is thought to be required.
In indicating those opinions, are you in effect saying that you don't see any conflict between a board member's, say, loyalties to Burswood Limited and their loyalties to CRL?
Conflicts could potentially exist, but could also potentially be managed.
Do you think that it is appropriate for CRL to have to use its best endeavours to ensure that the Perth Casino is conducted in such a way as to promote tourism, employment and economic development generally in Victoria?
Sorry, could you repeat the beginning of your question?
Do you think that it is appropriate for CRL to have to use its best endeavours to ensure that the Perth Casino is conducted in such a way as to promote tourism, employment and economic development generally in Victoria?
I don't have a view as to whether it's appropriate or not, but that is what the document says. That is a term of the Victorian licence, I think.
Do you understand that residents of Western Australia might feel a bit affronted by the fact that it's provided a licence to a company which ultimately has to or is subject to such a requirement?
Well, the licence isn't provided to CRL, it's provided to the Burswood entity. And that licence, as I understand it, was extant at the time when the government of Western Australia approved the takeover of Burswood by what became Crown Limited. So it's not new, is it?
And so that's your view, is that we shouldn't feel affronted because we should have that because we've accepted it?
Well, I don't have a view as to whether anyone should feel affronted. I'm simply stating the fact that that condition has been in place for decades and was in place at the time when the Western Australian government approved the change in ownership of Burswood, as I understand it.
So since you've been connected with CRL, has there been any discussion about whether that requirement should be deleted or retained?
No.
And I gather from your answers is that you don't think that it should be deleted.
I haven't expressed a view on that. I don't have a view.
So it's not that you don't think it should be, it's just that you don't have a view.
I don't have a view.
Now, in considering whether to become a director of CRL, did you give any consideration as to whether CRL being the ultimate holding company of the monopoly casino in Western Australia has any responsibilities or duties as that ultimate holding company of a monopoly casino licensee that are unique as compared to its responsibilities and duties in terms of governance of any other sort of service provider?
Sorry, I don't understand the question. Did I give consideration?
Yes. Did you give consideration to what the responsibilities and duties are of CRL as the ultimate holding company of a monopoly casino licensee that might be different to the responsibilities and duties of the ultimate holding company of any other sort of service provider?
When you say the ultimate holding company of any other service provider, I don't understand what you mean.
Well, what I'm saying is
Perhaps
when you considered whether you would become a director of CRL, did you consider
Yes.
the nature of the business of CRL?
Yes, I did.
Did you consider the duties and responsibilities of CRL in terms of the governance of its businesses?
Yes.
And did you consider its businesses, one of which is being the ultimate holding company of the Western Australian casino licensee, to have any particular duties and responsibilities that are different from being the ultimate holding company of any other sort of business?
Well, yes. The holder of the casino license is a particular, running a casino is a particular type of business that has different characteristics to many other types of businesses. Yes, that is in the nature of Crown Resorts business.
And what are those peculiar rights, duties and responsibilities that are owed or that might be owed to the Western Australian community?
Well, as you say, being the holder of a monopoly casino licence in that state would come with obligations to comply with the terms and conditions of that licence and to take into account in those operations and in its management of risks associated with that business, the context within which it operates.
And that's as far as you thought about it?
Yes.
Thank you, Ms. Ward.
Ms Ward, I've got a couple of questions for you. Can I start with the ground that's been covered about the proposed addition of an Article 15.13? We don't need to go through it again, I think, but in answer to some questions from Commissioner Jenkins, you acknowledged that it is at least possible that there might be conflict between the boards of Burswood Limited and CRL on a particular issue, but that conflict could be managed. Do you remember saying that?
Well, I was referring not to conflict in the general sense between the boards, but conflicts of interest or duty that were held by individual members of the board.
Yes, I'm sorry, that's
which I thought was the question.
what I was getting at. Now, I certainly do not want to get into a legal debate here, but
Thank you.
as I understand the position, under Section 187 of the Corporations Act, that article reflects Section 187 of the Corporations Act, which says that if the company's constitution permits it, then a director may act in that way. Now,
that's my understanding.
Now, so that the default position then, if that article is not there, the default position is the general law relating to directors' duties. Now, I acknowledge that the general law about directors' duties in company group situations is complex, and not difficult either to understand or to apply. But given that there could be a conflict, could be a conflict of interest, which you say could be managed, what do you say to the proposition that the inclusion, the amendment of the Constitution of Burswood Limited to include that is in fact looked at from the point of view of Burswood Limited and its directors, a backward step?
I don't know whether that's a backward step. I would need to take some legal advice on the propositions you're putting to me.
All right, I won't take it any further. On a different topic, you're awaiting probity approvals from the regulators before your appointment to the board of CRL can be confirmed. Can I ask you, what's the process that is gone through, because you've just been through it in the last 4 weeks? What is the process and your involvement in the process by which you get approval? That's one question. And I'm assuming that one of the applications for probity approval is to our Gaming and Wagering Commission.
Yeah. So the process is I was provided with assistance from the Crown compliance team as to assist me in figuring out what was needed to be done. What was needed to be done was that I had to complete application forms, one of which was to the Gaming and Wagering Commission in Western Australia, one was to the ILGA, I'll get the name wrong, but the New South Wales regulator, and one to the VCGLR seeking approval in Victoria. And each of those forms was different and required different information to be provided by me. And I compiled the information, completed the forms and lodged them with the relevant regulators.
And to your knowledge, has there been any response from any of the regulators by way of a request for further information or anything of that nature?
No. I've received confirmations from two of the regulators that they have my application because I was required to lodge those two electronically, and they've told me that they'll be in contact if further information is required.
And which is the third of those regulators?
The third is the West Australian regulator, but that application was required to be lodged by Crown, is my recollection, and so there could have been confirmation from the Gaming and Wagering Commission to Crown, but I'm not aware of any requests for information. And
at the moment, is the intention of your directorship to be simply the main board of CRL? Has there been any discussion about you going on any subsidiary of CRL?
There was preliminary discussion prior to me being invited to join, and that was around my availability to join the Crown Melbourne board. And no doubt there will be requests that I join some of the committees, but we haven't had those conversations as yet. I'm not yet a director, I'm an observer, and those conversations also would be with Dr. Switkowski, who's also not yet approved, so he's not yet chairman.
All right, thank you very much. On a separate topic, if you could, I'm going to your witness statement, paragraph 6 little e, this goes back to your role as General Counsel of National Australia Bank, and you refer there to two specific, if I could say, specific crises. One was the collapse of Storm Financial, and the other was the write-down of the synthetic collateralised debt obligation problem, which I think was more US-based, wasn't it?
Yeah, the CDOs were, the portfolios were US-based, is my recollection.
Now, my question to you about those, they're two specific crises. And my question is, to what extent did your involvement include what might be termed a root and branch or a root and cause analysis to try and identify systemic deficiencies which either caused or contributed to the particular issues?
So regarding the collateralised debt obligation portfolios, my role was not understanding the root cause of the issue. My role was in relation to overseeing the class action which was issued. It was a shareholder class action resulting from the write-down in the value of those portfolios. So it was not the investigation of the how the matter came about. In relation to Storm Financial, my role was much more deeply involved in investigation and remediation activities, and by that I mean understanding which customers of NAB may have been impacted one way or another by the collapse of Storm, and it involved questions of any remediation required. And in investigating those things, there was also an investigation of what NAB's role and obligation was to those customers. So that was much more a root cause analysis. And my role at that time, I was General Counsel for Australia, and I was a part of the steering committee that led the NAB response to the Storm collapse.
And as a general proposition, would you agree with the statement that where you get a crisis, it's an opportunity for the company concerned to learn, to identify systemic deficiencies, and to as a marker of how to remedy them?
Absolutely, and how to avoid or perhaps put in place preventative measures to try and avoid further crises of that nature. Yes, I would.
And to that extent, the looking at something by way of a root and branch or root and cause analysis is an important part of the process?
Yes.
All right, thank you.
Yes, I agree.
Ms Thornton.
No re-examination, thank you.
Ms Ward, thank you very much for giving us your time. We appreciate it, and we have been helped by your evidence. Because this is a fluid situation, I think we should leave the summons in place. I doubt that we would need to speak to you again, but just in case, we'll leave it there. You'll be advised in due course when the summons is discharged, but in the meantime, you're clearly free to go about your other endeavours, and you have our gratitude. Thank you very much.
Thank you, Commissioner.
We'll now adjourn, and we'll come back at 2 p.m.
All rise.